Thanks for joining us. Welcome everyone to today's webinar, The Quiet Revolution Part 2, State Data Protection Laws for 2019. Joining us today is Scott Giordano, VP of Data Protection at Experian. Scott's a highly regarded data privacy attorney with over 20 years of experience. Welcome, Scott. Please take it away.
Wonderful. Thank you, Abby, and thank you everyone for joining us this afternoon or this morning. So let's get started here. Our agenda, I'm going to share with you some things that I think you absolutely have to leave with. We'll walk through some different kinds of statutes for 2019 for the first half. So those that address data security standards, those that regulate the sale of personal information, and then those that address breaches and a couple other things. Also answer your questions. So if you email questions in, yours will go towards the end. So if you have questions during the course of this, please send them in. I will get to them if possible. And please do answer the questionnaire and review or whatever you want to call it at the end of the webinar here. That's how we get our ideas for new webinars. So without further ado, if you leave with nothing else, the first wave of nationwide changes to our data protection landscape started in 2018. We had about, I'm going to say 14, 15 new laws. And if you've been on a previous webcast with me, you've already seen that webinar. That's the Quiet Revolution. However, we've got right now about 18 new laws, and that's just in the first half of 2019. I expect more on the way. So the scope of these laws goes beyond a state border typically, in some cases globally. So if you do business in state X, we'll say Nevada, for example, and they pass a new law, which they did, then you are going to likely be subject to that law if you are from another state or even potentially from another country. With respect to breach notification laws, typically they contain other requirements. This is kind of the dirty little secret about breach notification, is that they usually have things like data security standards or requirements for screening third parties or other things. So I'm going to call those out when I see them. Also, watch out for without undue delay clauses. I'll talk about those are gotchas. Every state has its own definition of personal data. Some are very generic, some are very specific. So we'll talk about those. Just be warned that you're going to have to check for every state. I've put together some state privacy guides that have that, so more on that later. And then don't expect the federal government to help. I know people still think the federal government's going to come in and do a one-size-fits-all data privacy law by the end of the year. I do not see that happening. And then finally, data inventories. That is to say a collection of where all your personal data is in your organization. Still key for compliance. So let's go to the first slide, and I apologize in advance if we zip through these. If we don't finish the material, you'll still have it on the slide. You can have a look at it. These are the compliance deadlines coming up, and so you can see some have already passed. So Ohio's data insurance law, Massachusetts had an update on their breach notification, so did Utah. Virginia's is coming up. Actually, I take that back. Virginia's already passed. So now we have Arkansas coming up and New Jersey. If you go to the next slide, Abby, you'll see that we have more, though. These are all the ones that are coming up in October and in January 1st, including California Consumer Privacy Act. I know that you're all busy getting ready for that, but you can see there are lots of other ones in scope here. So we're going to touch upon all of those except CCPA. We'll have a separate webinar for that again. And then if we go to our final slide here, you have some more compliance deadlines that are coming up in March and even into January 2021. So lots of stuff on the horizon. And I know many of you have heard that the New York Privacy Act is allegedly going to be signed by Governor Cuomo. I don't know. As of this moment, it has not yet been signed, but I am standing by waiting for this. If it does get signed, I will do a webinar on it because it's likely as impactful as CCPA. So more to come. Let's go to the next slide, Abby, and let's talk about some of these. I'm not going to hit on all these states. I'm going to hit the ones that I think are most relevant to you. So let's do Oregon first because I know we updated you on Oregon last year, but Oregon's got some updates to their updates. So let's go to the next slide, Abby, and we'll talk about Oregon. This is addressing data security standards. So this is HB 2395. It's effective in January of 2020. And so it requires manufacturers of internet-connected devices, although they just call them connected devices, to equip them with reasonable security features. So this is any manufacturer of an internet-connected device. Think about routers, for example. They're notorious for having all kinds of flaws in them. This applies to any manufacturer in the world. So it's not just those in Oregon. And this protects Oregon consumers, not businesses. This is different from the California version, which I'll do a little compare and contrast in a minute. But think of this as your IoT law. Did California's probably earlier in the year we talked about that, or maybe late last year. This is their version of that, and it's very similar. In fact, I think they copied and pasted most of the law from California. If we go to the next slide, I'll dig into some of these things. So what it's asking is that a manufacturer of a connected device is going to be required to use reasonable security. And you might say, well, that's great, Scott. What does that mean? Well, a couple things. It can either be a means for authentication outside the network, so meaning that you have to generate a unique password for each device, which I know drives manufacturers nuts, but this is what's required, or require that the user generate a new means of authentication, which is not terribly dissimilar from the first idea. So essentially what they're asking is that the user has to change something, otherwise it doesn't work. You can't rely on default passwords anymore, which is a great vulnerability in everything, not just internet connected devices. Or you can comply with federal law or regulations that apply to security measures for connected devices. Unfortunately, I'm not aware of any at this point, but I presume that some will come down the pike at some point, and therefore they can use that. So it's nice. I like it. This is where we are with this. So a copy, if you will, of California's IoT law. Let's go to the next slide, and we'll dig a little deeper into what California does versus what Oregon does, because I know everyone was going to want to know what's the difference. Essentially, for the first paragraph where it says manufacturers equip devices with reasonable security, so same idea, it's just that they made it longer. And then the second idea, same exact thing. They've copied and pasted this thing, unique password or unique means of authentication. So basically the same thing. I guess they figured if it works for California, it'll work for Oregon. So you can see that they're essentially the same, except that California's applies to commercial devices as well, not just to consumer. Let's go to the next slide. And so this is effective 2020, January 1st, 2020. No duty on the manufacturer, unaffiliated third-party software. So if there's something that breaks based on affiliated third-party software that the user chooses to connect, it's not their problem, essentially. So if you're one of those folks like me that wants to download new OSs for your router, for example, there's no duty to that kind of software. No duty to prevent the user from having full control, meaning downloading a OS like DDWRT or one of those and modifying your router or what have you. So not surprising, same thing as in California. And there are exceptions for providers, electronic marketplaces, devices subject to federal law enforcement, and healthcare providers. That's probably very few, if any of you, with the exception of maybe healthcare. There's almost always a healthcare exception, though. And let's go to the next slide. A couple things. Doesn't require vendors from directly enforcing this. So the vendors aren't going to come after you if you don't change the password, okay? Or they aren't going to come after the manufacturer to go and make them change the password. So that's the good news. They don't require manufacturers from blocking consumers from modifying things, which is great because a lot of us like to modify things, and doesn't require suppliers that are downstream to provide security. Essentially, it's up to the original equipment manufacturer coming oftentimes from overseas. So that's Oregon. That is their IoT law, effectively. Let's go to the next slide, and we'll talk a little bit about, doesn't apply to if you modify devices and all those fun things. Let's go to the next slide, Abby, and let's talk about penalties. No private right of action. The AG's office will enforce this. This is the second IoT law of any kind, and it applies to any company, as I mentioned earlier, selling devices in Oregon. So not just those that are located in Oregon. Potentially, it's a global application. Finally, if you have not read Click Here to Kill Everyone, highly recommend it. It's great on IoT security. I don't get a kickback from these guys. It's just a good book to read. That is Oregon. Abby, any questions that have come in before we dig into the next one?
Yes. What does Comprehensive Written Information Security Program mean?
It means quite literally that you have policies, procedures, plans, guidelines, and standards completely produced at your organization. You have management buy-in, and you have a system to enforce them. That's a Written Information Security Program, or a WISP. I did a presentation on this, I think, earlier in the year, and it's really important that if the state requires a WISP, which is many of them, that sometimes they'll even require them without calling them a written plan. They'll just say, have a formal information security program. Essentially, that's a WISP because it has to be written. Otherwise, how could you keep track of it? So that's a comprehensive plan. Typically, it takes a long time to develop one. I've worked at some places where it took us probably 9 months just to work on the data classification piece and make sure that was right and that was accepted. And then from that, other things hooked into it like policies and procedures and breach notification, all that. So it takes a while. If you don't have one, now is a very good time to start developing one.
All right, that's all the questions we have for now.
Okay, then let's go to the next one. These next 4 states are all subject to the insurance data security law. So I'm just going to do the law, and then if there's something specific about a state that you want to know, you can actually look it up on the state website. They almost all have state websites for insurance commissioners. So, and not surprisingly, on the insurance data security law, this was passed first last year by South Carolina. Essentially, it's a copy and paste of New York's law that governs financial institutions. It applies to insurance brokers, insurance carriers, insurance anything basically. And not surprisingly, it requires a comprehensive written information security program, or a WISP. So this is something that's going nationwide right now. About 4, maybe 5 states have this, but this is something that essentially all 50 states will have. This is something the Department of Treasury has been pushing, and so you can expect to see this coming to your state if it hasn't already. So it tracks Part 500, which is New York's version of this. Theirs was the first one. Also includes third-party service providers. So it's important that you take a look at some of the requirements of this law, because you essentially have to push your requirements onto third parties. If third parties say, oh, it doesn't apply to me, make sure that you call them on this, because it absolutely does apply to them. And they should know by now that it applies to them. So it applies to insurers domiciled in a given state, and it protects the residents of a given state. Let's go to the next slide. So what does this do? Typically, it asks for about 6 big things. It asks for a risk assessment, which is not surprising because the controls are a function of the risk. Appoint a person to lead the program. So they don't use the word CISO typically, but the New York's version does. Other ones do not use the word CISO, but the implication is that someone is leading the program, or you have a collection of persons. Maybe you have a director of security and you have a chief privacy officer. But basically, you have to have person or persons to lead the program. You have to report to the board of directors so they know what you're up to and that you're actually doing an effective job. You have to screen third parties and impose that written information security program that I've mentioned a couple times now. You need an IR plan, and you need to investigate cybersecurity incidents, which can be just about anything. Let's go to the next slide. This is the definition of non-public information, which is this law's version of PII, or personal data or personal information. So whenever you see something like this, think personal information. It's the same idea. They have to use a different phrase, otherwise that would be too easy. So here you can see that it's business-related information. So this could be intellectual property, trade secrets. It could be attorney-client privileged information. Or for number 2, it could be the kind of things that you would expect to see as personal data, like a social security number or a driver's license number. Or for number 3, this is any kind of healthcare related information. So if this sounds like a copy and paste from HIPAA, it is. And I mean, that's great. If you're going to use healthcare data as something that you want to protect, then HIPAA is a great thing to copy. Let's go to the next slide. A couple changes coming up to the GLBA safeguards and privacy rules. You can find these on these websites here at the Federal Register. They're not law yet, but they're being considered. I put them there for your edification. If they do go live, I will do a webinar on those as well. They are copy and pasted from the New York law. So you can see how this thing has all come full circle now. The federal government is actually copying the state government, which is kind of an interesting irony there. Let's go to the next slide. I'll also know that these upgrades that I just mentioned to you apply to financial institutions, and that definition is very expansive. It's not just banks. Just basically, if you handle money, you're a financial institution. I'm being a little bit glib there, but it's a very broad definition. So if this does go live, I will do a webinar and we'll describe just what those are. Let's go to the next slide. These are the compliance deadlines for insurance data security. So if you're in Ohio or Mississippi, the deadline has already passed. You can see that Alabama and Michigan, though, are coming up soon. So that's the insurance data security law. If you were on the previous webcasts last year, same law. Essentially, it's going from state to state now. Let's go to the next slide. Abby, any questions come in before we do the next section?
No questions at this time.
Okay. All right. So these 2 statutes regulate the sale of personal information, not unlike CCPA, but they're very narrowly construed. So I'll give you an example. Let's go to Nevada, which is the next slide. This law just popped up. It was a little bit of a surprise. So this is SB 220. It's effective in October, so in a couple months. It enables consumers at any time to direct the operator, so essentially the data controller, if you want to use it in GDPR terms, to not make any sale of the covered information that the operator has collected or will collect about the consumer. So this is very CCPA-like, not terribly surprising. So what's an operator? It's someone that operates an internet website or an online commercial service. They collect and maintain covered information. There's a definition of personal information in this law, like everything else. And if you purposely direct your activities toward the state, then you're captured by this law. So it's really designed to protect Nevada residents, but it applies to anyone that's doing business in Nevada. You don't have to be located in the state to do it, though. So if we go to the next slide, we'll dig a little deeper here. So a couple things that you as an operator have to do. Establish a designated request address. So that could be an email address or some other special purpose site with a web form that the consumer can fill out and ask you for help. And then you've received a verified request. You shall not make a sale of that covered information that you've collected or will collect about the consumer, and you shall respond to a verified request within 60 days. So again, very similar to CCPA, although I believe CCPA is 45 days as the limit, but otherwise this is really drawn directly from CCPA. So essentially, the do not sell my information portion of that was copied and pasted into this, and this is essentially what the law seeks to do. Let's go to the next slide. So this is Maine's version of this. Maine's is a little bit different in the sense that it prevents sale of consumer data by ISPs. ISPs see a lot of data, not surprisingly, because they're seeing everything that you're up to on the internet. So this applies just to ISPs, and it protects Maine residents. So you could be an out-of-state ISP or potentially someone that has bought the data from the ISP, and this is either going to directly or indirectly apply to you. So go to the next slide. I'll dig a little bit deeper into this. So a provider, so that's an ISP, you can't sell, disclose, share personal data without consumer consent. The consumer can prevent the disclosure of it by asking the ISP not to disclose, and the provider can't refuse that if you ask that of them, and they can't charge a customer or offer or penalize them or otherwise say, sorry, we're going to punish you for this. So there are some exceptions, but by and large, this is a mini version of CCPA in the sense that it's just focusing in on the data that ISPs would be selling, and presumably they would be selling a lot of this. I would not be surprised to see other states copy this law. It's interesting. You never know what state's going to come out with a law like this, but in this case, it was Maine. Let's go to the next slide. Personal information. So person identifying information about a customer, so their name, their billing address, SSN, demographic data. And let's go to the next slide. You can see a lot of stuff here. This is very interesting. So think about all the things that an ISP has to look at. A web browsing history, your usage history, geolocation. There's a ton of stuff here. This is all the kind of stuff that ISPs would love to resell. And this is the reason why this law was passed. They can't resell this now. So you can see it's a long list of things. So if you're an ISP, you're probably doing a data inventory right now, getting a look at the kind of things that you collect or that you process from your customer base. Let's go to the next slide. So some actions that you have to do. Take reasonable measures to protect personal information. And this is interesting because you're going to see these in a lot of laws now. They're not just saying don't do this or don't do that. They're saying you shall take reasonable measures. So think about how many laws like GDPR say reasonable technical and organizational measures. Same exact idea. It's just that they're doing it here for this specific use for ISPs. And in implementing the security measures, what you have to do is take into account essentially the risk factors. So the provider's activities, the sensitivity of the data, the size of the provider. So essentially what they're saying is you're doing a risk assessment. This is just another way of saying the same thing. And I've seen this language in other laws as well. You'll find legislators will do this a lot. They'll look at everyone else's law and then just take pieces of that and put together their own law. So you'll see a lot of the same stuff. But this is essentially a risk assessment writ large, just by a different way. Let's go to the next slide. So statutes addressing breach notification requirements. So you may say, oh, Scott, just more breach notification. We don't really need this. Here's why that's not true. These laws almost always address things other than breach notification. And even though they may have a breach notification statute already, they're adding all kinds of things to it. This is probably the most common form of data protection, is when a state updates its breach notification law, and I'm using that in air quotes, but that's what they call them. So we'll go to the next slide. We'll talk about Massachusetts, and I may not get through all these slides, but I'm doing the ones that are in order of when the law goes into effect. So Massachusetts is, I believe, has already passed the deadline. Let's go
Scott,
to the next
question
slide.
for you.
Oh,
Sorry,
sure.
pertaining to Maine. The
Sure.
question is, what about the data the ISP already has? What do they have to do if a resident says no to sharing?
Oh, that's a very good question. I don't know if it's prospective or respective, so what I'll do is I'll run that to ground, and then I'll put that in the blog, and you guys can have a look at it there. It's a great question. And by the way, any questions that I don't answer, actually all the questions I answer or don't answer, we'll put up on the blog. So it usually takes about a week to put them up. So if you were on last week or 2 weeks ago, the webinar I did, we should have those blog updates tomorrow for you. So yes, definitely, I'll make a note of this, and we'll get an answer for you. It's a great question. So Massachusetts H4806. So this is deadline's already passed. So presumably you've already had a look at this. This is a update to their breach notification law, and it protects consumers and applies to everyone. So this is one of those rare laws that's not just going to businesses, also goes to nonprofits and government agencies. So let's go to the next slide, and we'll dig into this. So I really want to highlight this. Provide notice to affected residents whenever there's a breach as soon as practicable and without unreasonable delay. And here's why I am highlighting this. Because most of these laws will say, get this done in 30 days or 45 days or 60 days, whatever it is. And that's all people look at. But they don't look at as soon as practicable and without unreasonable delay. And here's where this is a gotcha. Let's say, for example, that you've got an SLA with a vendor where you'll notify them within 72 hours. Or you do business with the Department of Defense. So you have a 72-hour deadline for them. Or you have a GDPR commitment, 72 hours. So say, for example, that you're geared up for 72 hours, but you have a breach and you don't update everyone as soon as practicable. What happens? Well, if you get into litigation and someone says, wait a minute, you had the capability of notifying in 72 hours and you waited 30 days, why did you do that? And so this is a killer, folks. So absolutely, when you see as soon as practicable, know that the standard is going to be held effective for everything you've got. So it won't be, if you have the capability, for example, for doing this for some vendors or some data or some requirements, it's hard to argue you can't do it for everything. So just keep that in mind. Whenever you see a number like 45 days or what have you, but you see as soon as practicable and without unreasonable delay, take note, that's really the standard you want to have. And so you have to look at your other commitments and see, well, what have I done for those? Because otherwise, you're having two different standards and it's just going to look bad if you get involved in litigation. Also, Massachusetts may take the position that any unauthorized acquisition or use by a third party triggers a notification obligation. Now, where did that come from? Think about Cambridge Analytica. A third party was unauthorized using the data that they had gotten from Facebook. That triggers, in this case, the notice. So that's why you have to police third parties. And earlier I mentioned about written information security programs and pushing them on your third parties. This is the reason you do so. So everyone has the same standards. You're essentially playing from the same sheet of music. Let's go to the next slide. So what do you have to do? All kinds of things. Notify the AG and the Director of Consumer Affairs of all kinds of information, like the nature of the breach, how many residents were affected, et cetera, et cetera. You can read this, but the point is that all the pertinent information that you would find, say, in your data inventory, for example, would come off and would go into this report. So, and particularly if you've got more information and it's more precise, the more the better, and the sooner the better. This really makes things look so much better. If you have a breach, you're able to tell the authority, hey, I've done my homework, we know what went wrong, and here's what we're going to do to fix it. Being able to do that in 72 hours is the gold standard. I know that many of these laws don't require it per se, but it really represents the gold standard nowadays. Let's go to the next slide. More information here about what you have to provide. Again, you guys can read this offline, but this is something that should go into your breach notification program. Let's go to the next slide. So this is Utah's update, and again, this is effective right now. This is an amendment to their existing personal information protection law. applies to Utah residents, not surprisingly, and to anyone who conducts business in the state. So let's dig a little more into this. So, actions required. You're going to implement and maintain reasonable procedures to prevent unlawful use and disclosure. Notice how they always have the unlawful use clauses here. Again, that's for third parties. And then destroy records that are not to be retained. So if you're not using it, don't plan on using it, destroy it. That way, if it's not there to lose or to be manipulated, it can't hurt anyone. If a breach occurs, do an investigation. And if it's likely that there's fraud or theft, then notify again. Most expedient time possible without unreasonable delay. If it's a third-party service provider, notify the customer immediately. So notify your customer if you're a third-party service provider. Again, folks, whenever you see most expedient time possible, make sure you note that, because that's a gotcha for you, and it occurs in most of these laws now. And in fact, when I do a summary of this a little bit later on, probably in the month, I will make a note of all of those. Let's go to the next slide. So penalties up to $2,500 per consumer, up to $100,000 total, except, and this is an interesting formula, if there's 10,000 affected consumers from Utah and 10,000 from other states, then you can get a larger amount. And also the AG may bring a action for an injunction as well, which could put you out of business in that state potentially. So some potentially draconian penalties. Let's go to the next one, and this is Virginia. Now you say, hey, wait a minute, Scott, didn't Virginia update their breach notification last year? Yes, they did. They've done it again. So this one applies to corporations, so anything that's for-profit, nonprofit, and government agencies. So again, this is noteworthy for that, and it's great to have that apply to everyone, not just to corporations. So we'll go to the next slide. Personal information, first name, last name, or first initial last name, and then things you would expect: Social Security number, driver's license number, your bank account, or your passport, or your military ID. I put those in blue because those have been added. So this is the standard, if you will, breach notification law that Virginia has. They've updated this to include those things as well, so that's great. For many of us that travel, we use passports or military ID. Let's go to the next slide. We'll talk about Arkansas. So this is effective shortly, and this expands their Personal Information Protection Act to include biometric data. Also adds notice to do certain things after a breach and mandates retention of breach reports. So not surprisingly, protects consumers and applies to businesses in doing business in the state. Let's go to the next slide, and we'll find a little bit more about this. So now they've expanded the definition of personal data. It's got all kinds of things. So when they say biometric, that can be just about anything. So you would think that it's just a fingerprint, for example, but face print, which presumably that's what the government does for facial recognition, retina scan, hand geometry, so all kinds of things. DNA, by the way, I know what they were trying to say here. What they really mean is that they've taken DNA and digitized it. Obviously, real DNA they couldn't do anything with, but that's the idea, is they've digitized your DNA or anything else that's uniquely a biological marker of yours. So they've included a anything and everything clause at the end here. So where would this come into play? Keep in mind that if you have a security system, you're using facial recognition, you're using handprints, what have you, that information is something that if it's breached, typically it's going to be visitors to your site or your employees. They're going to be the ones that will be affected. You'll have to notify them. Let's go to the next slide. So you have to notify if more than 1,000 individuals are concerned here to the AG's office, and at the same time that notifications are sent to the individuals or within 45 days after there's a reasonable likelihood of harm, whichever comes first. So reasonable likelihood of harm, what does that mean? It means that you've done an investigation and you said, you know what, if bad guys get access to this data that's been lost, it's going to substantially harm someone. There could be perhaps financial issues, someone could break into someone's bank accounts because they've used multi-factor authentication using biometrics, etc. If there's a reasonable likelihood of harm, then you've got to notify individuals. And as a practical matter, you should be notifying them even if it's fewer than 1,000, but here the threshold is 1,000. Also, retain a report about the security breach for 5 years and submit a copy to the AG's office if the AG asks you. So this is something that is, I haven't seen this yet, but this is something that will probably be copied by the states. The idea that you want to develop a report and retain it for review, especially if there is a potential for litigation. Note, this is a very good time to get your attorney involved if you're developing this report, because you may want to develop it under attorney-client privilege so that if you want to waive it, you can, but at least you've got that option. Let's go to the next slide. So New Jersey, effective soon in September, this amends their breach notification law, as I mentioned earlier. So it protects New Jersey consumers and applies to any business. So it can be sole props, nonprofits, financial institutions, so just about anyone that is a for-profit or a nonprofit. Let's go to the next slide, and we'll talk a little bit more about this one. So updated personal information. So the first name, first initial, last name, it's a very common standard, plus any of these. And what they've added here is number 4, username, email address, anything really that's electronic that is something that will allow you to access an online account. This is something that be qualifying under this here. So this is something they've added to their breach notification law, and it's something that quite frankly should have been there in the first place, but they're updating that. Let's go to the next slide. So actions required, a couple things. When breached, a business must notify the customer. Again, most expedient time possible without reasonable delay. If it's a service provider, notified immediately. So you saw this from another law, they just copied this from another law. And so as a practical matter, most expedient time possible is going to be really fast. So review again your commitments to other parties and get an idea of just how fast your standard is, because that's what it's going to be for consumers in New Jersey as well. Before notifying the consumers, notify law enforcement as well, because they may want you to hold off until they do an investigation. I'm going to stop there. Any additional questions or comments from the audience?
No questions at this time. Friendly reminder to all attendees, you can enter questions in the GoToWebinar console and we'll ask those live on the air. Thanks.
Wonderful, thank you. Let's go to the next slide. And so this is Maryland. So this is October 1st. Expands requirements under breach notification, protects consumers, and applies just to businesses. And let's dig a little deeper here. We'll find exactly what you've got to do if you're doing business in Maryland. So scope of breach notification now is expanded. So you have to notify folks. Guess what? As soon as reasonably practicable. No later than 45 days. Again, folks, I know I beat this to death, but don't look at the 45-day number. Look at reasonably practical, because it's just too easy to be held to that standard. Also, those businesses can't charge the owner of licensee of data a fee for whatever information necessary to notify folks. So I think there's probably some shenanigans going on with notifying people and charging fees, and this essentially puts the kibosh on that. Also, prevents this is amazing. Prevents the owner of license or the license of the information about the breach from using it other than providing notification. So what does this mean? What are they? Again, there were shenanigans that happened after breaches before, where perhaps companies were trying to sell services to them to fix the breach that they made. So this essentially puts the kibosh on that too. So it's interesting how these clauses are creeping up in these laws here. We'll go to the next slide. Illinois, this updates their Personal Information Protection Act. As you probably are guessing, most states now have something called Personal Information Protection Act, or some variation on the theme. Protects Illinois residents, and it's any data collector that owns or licenses personal information about an Illinois resident. So again, it doesn't have to be someone that is located in Illinois. It can be basically anyone doing business in Illinois and has information about the Illinois resident. So let's take a look at what we got here. So notify the resident at no charge about the breach. Disclosure shall be made in the most expedient time possible without unreasonable delay. And if you're a third-party service provider, notify your customer immediately following the discovery. So nothing unusual here. This is pretty much part and parcel of everything we've talked about today. Let's go to the next slide. This is Oregon. And so this amends their act that was already amended last year, the Oregon Consumer Identity Theft Protection Act. So what you have to do, if you're a vendor and you discover a breach or you believe there's a breach, then you have to notify your customer as soon as practicable, no later than 10 days after discovering a breach. So essentially the same language we've been seeing all day today, but this is really geared for third parties. If you have a contract with another vendor that has a contract with a covered entity, then notify the other vendor. So essentially go up the chain to make sure that everyone that needs to be notified has been notified. The vendor's got to notify the Attorney General. The vendor was subject to a breach that involved more than 250 people, which is basically might as well be zero. Then you have to notify the AG. So effectively, Notify the AG if you're a vendor. Let's go to the next slide. This is Texas. So this expands requirements under their breach notification statute. Note that Texas had two big privacy laws that did not go through this year. I was following them throughout the course of the year. They were very aggressive. They did not make it. Look to the next session, whenever that comes in next year, and we shall see if they update this. But this was a big deal. They almost passed those two laws. So what they wound up passing was this, which is just an expanded requirement under breach notification law. It protects consumers and applies to businesses and persons. So let's dig into this. Let's see what they've asked. So not surprisingly, he must notify without unreasonable delay, no later than 60 days. If more than 250 Texas residents, then notify the AG's office. And then it gives you a list of the content. And the content you've seen earlier here, Massachusetts had a long list of content. They've got this here too. So detailed description of the nature and circumstances, number of residents, measures taken by the person regarding the breach. When they say by the person, they mean the company, et cetera, et cetera. So lots of information here. As you probably have guessed that this is a trend, that you have to have a standard package of information that you supply whenever there is a breach. And so this is just an example of that. Even if they didn't ask you for this per se, it's a great idea to have all this ready to go whenever there is a breach. Let's go to the next slide. And so this is Washington. This is my state here. So effective March 2020, there was also a clone of the CCPA that went through the Washington legislature this year. It almost got passed. It was canned at the very last second. I expect to see it back next year after CCPA goes into effect. But for now, we have the Washington HB 1071. So this expands requirements under Washington's breach notification statutes, applies to or protects consumers like me, and applies to businesses and persons. So let's dig in and see what Washington has cooked up here. So this expands the definition of personal information. So Social Security number, driver's license numbers, account numbers, dates of birth, private key that's unique to the individual and used to authenticate or sign an electronic record. I thought that was pretty cool. So think about those of you that are involved in public key encryption that you may have used in any capacity. Maybe you used it for electronic signatures or what have you. That's what they're talking about. So it's nice they've acknowledged that. Let's go to the next slide. So other things, student military passport, like we saw earlier in our discussion, health information, policy number, identification number, which I thought was good, information about a consumer's medical history. So really lots of things that are medically related, and then biometric. So we saw Illinois has their biometric. This one is also biometric. Again, because it's very easy. If you have a biometric system that authenticates someone, if that's been compromised, then effectively it opens the door to all kinds of fraud and other kinds of things. This is directed towards that. Let's go to the next slide. So notify within 30 days. If more than 500 residents in Washington, then call the AG's office. You guessed it, most expedient time possible without unreasonable delay. So the content here, almost the same as the one we saw previously for Texas. So name and contact information, what information was subject to the loss, how long it's been going on, toll-free numbers of major credit reporting agencies, etc. So really same kind of stuff, and by now you're probably putting together a long list of information you want to put in your breach notification report, which is great. Let's go to the next slide. So how do we comply with this? If you don't have a data protection steering committee, honestly, folks, I know I tell this to you every time, now's the time to put it together, because all these laws really require that you are essentially across your organization, everyone's on the same page. And that means having a data protection steering committee that can say, these are the standards we're going to use, this is what we're going to do to develop a data inventory, these are the controls we're going to use, these are the standards for notifying someone, all those kind of things. That's something that you want to put together and get management's blessing and hopefully management's enforcement of all the things that you come up with. Someone mentioned earlier about what is a WISP. Well, a WISP comes from the Data Protection Steering Committee, or they may develop subcommittees where they may assign certain people, like the General Counsel, to write certain policies or procedures or what have you. But typically they'll be the first place you start, and then they'll put together the rest of the documentation or have that out to a subcommittee. Also, determine who will lead the security team and who will lead the privacy team in your data protection program. So typically you'll have someone in the security side that will address all the breach elements itself, whereas someone on the privacy side will really talk about what personal data was implicated, what they were doing with it, et cetera, et cetera. So those two folks need to work together. Let's go to the next slide. So rationalize your requirements. What does this mean? It means that take all of these requirements that you've seen on this webcast and on the previous one on state data privacy, find the ones that are the most stringent and work with those. I would definitely look at a common set of controls like CSP Top 20, ISO 27K, etc., and have a third party provide a written assessment. Yes, I know you can do this internally on your own. It really carries a lot more weight when a third party does it. And politically, I think it may be more palatable to do it that way than do your own. People may say, oh, you're just saying that because you want this or want that. But having a third party come in and do an assessment really is crucial. Get your data inventory completed. You know, I hammer that every time we're on a webcast here. Identify third parties that hold your sensitive data, review your contract, and identify problems. And I got to tell you, folks, this is something you want to do at least quarterly, because if you have third parties who are licensing your data and they're doing things with it that are outside of what your contract says, you want to catch them as soon as you can. Because if you don't police them, these guys will get into trouble, and then it's going to roll back up to you. Create mechanisms for monitoring and reporting. So make sure that you have some kind of detective control where you can monitor what's going on, and if someone is doing something they shouldn't be, you're notified in, if not real time, close enough to it that you can put the kibosh on it. Because if you're not monitoring, you're going to be asked if there's in a lawsuit, why weren't you monitoring your network? And I'm sure all of you do this already, but it's something I want to emphasize. Constantly improve your data protection program. This is one of those things that I found is a big weakness, is that I've worked on projects with folks before where we do all of this work, we implement stuff, and then the program starts, so the day-to-day operations, I leave, I go on to something else, and they don't really do much with what they've got. It turns into shelfware. This is something that you really have to have a program that's day-to-day, and it's being updated at least quarterly, where you're looking at new threats, new problems, new legal implications, and saying what changes do you need to be made, because you want to prepare to defend yourself in court if things go south. Let us go to the next slide. So your questions answered. So if you sent questions in earlier, I'm going to answer them now, and if you've got additional questions, we'll go through all of them. So any focus on credit bureaus at state level? Yes, New York's law, Part 500, specifically addresses credit bureaus. I haven't seen other states do this yet. However, the FTC is implementing a new law that was signed into law in May, so that'll go live in September. And yes, you no longer have a fee for turning offer on a credit freeze. So if you have not done that, please take a look into that. You can just do a search for credit freeze and the word free, because now it's free. So I would recommend to do that, especially if you're not planning on using your credit for a refi or something like that. You might as well just freeze it so no one can use it. Which data protection privacy regulations or law has gone nationwide? I think the closest thing is CCPA at this moment. I mean, all of them have national implications, but really CCPA is the one that's going to be our GDPR, at least until New York passes theirs, and then we're going to have two. And when Washington passes theirs next year, we'll have three. So the net of it is that at the moment it's just CCPA. New York Privacy Act, that's what I was referring to earlier, seems to be coming fast. I'm monitoring this daily, so as soon as it passes, I will put together a webinar. I'll let you guys know, and we'll dig into it. What's the prospects for a single unifying federal statute to rule them all? The answer is somewhere between 0 and none. Okay, I just don't see it happening. The folks in DC can't agree on anything, so I don't see they're agreeing on this. Abby, questions from the audience?
Yes, a few questions here. The first one, is there any statute, law, or approach to have for the U.S. that you know of so far being country general for data protection, similar to the GDPR?
Not at this point, although the GDPR is going to wind up being that eventually. So Brazil has their version of GDPR, and because other countries want to participate in commerce in Europe, for example, Japan now has adequacy standing, meaning that there's no contract clauses need to be signed when you transfer data out of the EU to Japan. So this is something that you're going to see other countries starting to strengthen their regimes to the point where they effectively become a clone of GDPR. Again, ours are coming at the state level, but that's effectively what we're going to be seeing. So yes, over time it will develop, but they may not call it general data protection, but that's essentially what it's going to be.
Great. The next question is, do any of the state breach notification laws apply to organizations doing business in the state without regard to the state of residence of individuals affected by that breach?
It's a good question because you can make the argument that if the breach doesn't affect anyone, let's use Oregon for example. So if you were processing data of people outside of Oregon in your state and there was a breach, make a great argument that the Oregon law doesn't apply. And so then it raises the question, well, okay, what laws do apply? Well, look at the individuals, look at their states of residence and see what laws apply, because effectively, if you've availed yourself of being involved in interstate commerce, you can bet that you're going to be called into court in federal court, assuming you meet certain thresholds. It's almost a guarantee. So yes, if that were the case, which it would be odd, but it could happen where you could have data processing in Oregon but not have any Oregon residents in scope, then yeah, look at the law of the states of the residents that were breached and see what they say. So as you might imagine, this is a big kettle of fish, and that's why you really need to think this out thoroughly beforehand, because it's a mess if you're trying to do it and haven't planned things out.
Okay. Next question is, what does doing business in a state actually mean? This person's saying that they are in California, they have a website selling services that anyone can access. So are they essentially doing business in, say, New York, Nevada, etc.?
It's a very, very good question, and here's why. From an EU perspective, just having a website that's accessible of someone in state X for whatever reason it is doesn't make you amenable. So say, for example, that I've got a website here in the US, someone from the EU looks at it and says, oh, I want to buy that or whatever it is. They buy it, and the person or the company uses their data for advertising or whatever it is in violation of GDPR. Is that company subject to GDPR? Probably not, because they didn't direct their efforts to the EU. So in that case, having that website available to EU members, not going to be enough to get them under the scope of GDPR. Now, flip that on its head. Here in the US, it's a different story, because if you have a company in California, they've got a website that's available to all 50 states, it's a much more difficult question, because we just presume that any website we go to in any state, if something goes wrong, we've got protection from that state's law. So the short answer is that if your website's available to everyone in all 50 states, then you're likely going to be held liable or amenable to the state data protection laws. So if I have a company in California, my website's available to all 50 states, I have people in Florida that are subscribers or customers or what have you, and their data is breached, then I'm going to be held responsible for that. I'm going to have to look at the Florida data protection law and potentially California one, depending on how it's structured. So there's always two questions there whenever that takes place.
Okay, next question is, at one point, some state laws required reporting breaches greater than a certain number of individuals. Is that still the case?
It is. Most states have a threshold where they'll say 250, 500, 1,000. Occasionally I've seen it to 2,000, but basically I've seen 250 and 500 very common. So here's the problem with that, though. Even if you're not required to report the breach, say that you've got 200 and the threshold is 250, and those folks suffer as a consequence, then they're going to make the argument that you could have easily notified them, especially if you have notification requirements in other contexts. Going back to what I said earlier, if you're prepared to notify within 72 hours all kinds of data for federal government, for GDPR, for what have you, for New York data, and you're not offering that to everyone else that you're processing data for, it's going to look bad in court. So just because you haven't made that threshold, I would still be very cautious about not notifying people and then risking having them come back and sue you.
Great. How are data deletion requests fulfilled if the data resides in hard copy in a visitor guest book log, where visitors would manually enter their first name, last name, and other PII data?
Oh boy. No one's ever asked me that question. Aside from just blacking it out with a magic marker, I don't know how else you would do it. So presuming that there's no legal requirement for you to make a copy of that or hold copies of that for whatever reason, or there's a legal hold or whatever it is, assuming there's no requirement for that, then I would just take a big black magic marker and just erase it that way, or just blot over it that way, which I know is not a very elegant solution, but unfortunately, when you're dealing with paper, you don't have a lot of options.
Okay, next one is, with Privacy Shield under review by the CJEU, Should they
Mhm.
reply on SCCs and new agreements?
Well, here's the problem: is if CJU decides to blow up Privacy Shield and blow up model contracts, then what do we do? It would be a disaster. So the short answer, we don't really have a lot of options. I mean, yes, you can do binding corporate rules and all that if you have you're a multinational, but if you're not, then you're out of luck. And binding corporate rules, unfortunately, are really geared for those giant companies. So for what happens to the rest of us, if they choose to torpedo that, then we're all in big trouble because now you can't legally export data from the EU to the US anyway. So that's bad news, and I don't know what we're going to do. It's going to be a disaster. So I'm going to keep my eye on it. If it does for some reason happen, I'll put together a webinar and we'll bring on some guest attorneys to just deal with that, and we'll see what we can find. But it's going to be a big mess. I remember when Safe Harbor was torpedoed, and that created utter chaos. This would do it 10 times worse because standard contract clauses are used everywhere. I've probably read a couple hundred agreements that have those, or written an equal amount that have those. So definitely something we hope doesn't happen, but very little would surprise me.
All right, it looks like that's all the questions that we've received today. So I wanted to extend a thank you to everyone for joining us. Again, a copy of the PowerPoint presentation and a link to the webinar recording will be provided in the coming days. We hope to see you all at future webinars. Thanks and have a great day, everyone.